SJC-12293, Commonwealth v. Edward Curran.
Thank you. Ms. Kovner, good morning.
May it please the court, I'm Marcia Kovner representing Edward Curran. This case arises out of the denial of a motion in limine to admit expert testimony on the issue of lack of criminal responsibility at a Section 15 hearing in an initial SDP commitment under Chapter 123A.
Can you clarify something for me at first? Was that motion to admit expert testimony of lack of criminal responsibility based on the expert who concluded the defendant was not competent?
It's based on the testimony of Dr. Brown, who was the retained probable cause expert in the SDP case. Okay. There's a separate determination of not competent to stand trial back in the district court. In the Superior Court in the SDP case, he was also found not competent to stand trial.
Okay, but not by Dr. Brown?
By Dr. Brown and by Dr. Schoenberger of the court clinic.
Okay, so what was being sought to be admitted was only about criminal responsibility and not about competence. Is that correct?
Yes, because under Nieves, the case proceeds anyway, even if he's not competent.
Okay.
So the issue was,
all right,
can he be found not criminally responsible for the underlying criminal offense?
Okay, thanks.
So in other words, he was found not competent, as I said. The predicate offense was an indecent A&B in district court. He was a resident at a mental health facility, and he allegedly indecently touched a 59-year-old female medication nurse at medication time. So he was found not competent to stand trial in that case in district court, and then sent to Bridgewater State Hospital and committed there. He has serious mental health issues, schizoaffective disorder. He is under a guardianship and a Rogers order. The Commonwealth then filed the SDP petition before his civil commitment expired. Again, he was found not competent to stand trial in the SDP case itself, and then the case proceeded with a probable cause hearing. Probable cause was found, and then we reached the Section 15 hearing, which is where all the issues arose. Section 15 provides a proceeding for the court to determine, quote, whether the person did commit the act or acts charged. That Section 15 proceeding essentially substitutes for the criminal trial that couldn't be held in the district court because he wasn't competent to stand trial. So that's where the issue came. I filed the motion in limine to admit expert testimony and raise the defense that he wasn't criminally responsible at the time.
What would happen after that hearing? What would be the next step?
After that hearing, if it was found that he had committed those acts, then there's a right of appeal, and then the SDP case proceeds.
So then it proceeds to a determination regarding sexual dangerousness. At that point, would criminal responsibility information be permitted in?
I don't think it's, I guess you could do it in some kind of mitigation in that case, but it's not a defense at that point. You could use it as mitigation as circumstances of my client and, as part of the argument to the jury, but it's not a defense.
Are you arguing that part of the Commonwealth's obligation to prove whether or not he committed the act is a responsibility to prove some type of mens rea? And that enables you to raise criminal responsibility? Just
like in any criminal case, yes. Just like in any criminal case.
What's the mens rea requirement in an indecent assault and battery?
You have to have the
Is it a general or a specific intent?
Oh, I don't remember offhand.
Well, certainly someone can be not criminally responsible in a general intent crime, correct?
I'm sorry?
Certainly someone can be NGI in any type of crime.
Any type of crime.
Any crime.
Right, and he's seriously mentally ill. Dr. Brown opined that he...
I guess the difficulty is that the statute really contemplates kind of a truncated proceeding. And that's what the judge found, really.
And that's part of the problem. But if you look at the Burgess case enumerates different rights that the that the defendant would have. That was decided on equal protection grounds. Among the enumerated rights is retention of experts. There's no limitation on that retention of experts. It doesn't say only experts for certain things. In the Section 15 statute itself doesn't limit the defense.
But I mean, the real crux of it, as Justice Gaziano, I think, noted, is that you're saying that the statute, we should interpret the statute did commit the act or acts charge to mean did commit the act or acts charge with the intent required by the statute.
In a criminal way.
With the appropriate criminal intent.
Right, the same.
And if it is with the appropriate criminal intent, then you're saying criminal responsibility has to be determined. And if it's to be determined, you would have to do it by an expert.
Yes.
So let's assume you're right.
Okay.
Let's assume the judge then finds that your client was not criminally responsible. What happens then?
Well, that's an open question, and one of the reasons why we ended up here, because that's what the Superior Court judge said. Suppose I find that he committed those acts and that he wasn't criminally responsible for them, then what? There is, if in the criminal case, in the district court, if he had been found not criminally responsible, he couldn't be because he wasn't competent to be able to raise that defense.
Right, but let's assume he was competent.
But assuming he was competent and he was found not criminally responsible, then he could be civilly committed under the mental health statutes, the Chapter 123.
By statute. I mean, the statute provides for what happens.
Correct. And then if there's an issue of he's dangerous or whatever, he can be committed. And at the hearings under, I think it's 123, 16D, the district attorney gets to be heard too. So you could address public safety there.
Isn't there, in the SDP statute, there is a requirement, isn't there, that there be some kind of mental condition or defect that causes the petitioner to not be able, that renders them sexually dangerous? They can't control themselves. Is that basically the point?
Yes, it
So
has to.
doesn't that inherently contradict this need that you're stating there is for a finding of criminal responsibility on the underlying crime?
Doesn't inherently contradict.
Because if you find there is, that the person's not criminally responsible because they couldn't have formed the intent because of then it's basically eliminating the SDP requirement, the conditions of the SDP.
Right, and I think at that point, there should be no SDP. He'd be not guilty, NGRI.
I see, so he'd be not guilty, but
Then I would say the SDP shouldn't go forward. He should go off into the mental health
So the
system.
legislature certainly didn't contemplate the next step.
I'm sorry?
The legislature certainly didn't contemplate the next step. That's
And
the
that is
problem,
part of the
right?
problem, yes.
So what do you say should happen? And let's assume that we agree with you. Let's assume the judge finds him not guilty because of reasons of lack of criminal responsibility. Does the statutory consequence that would have happened if he had been competent to stand trial and the jury had so found kick in, or what?
In his case, he has a whole treatment plan with he's a Department of Mental Health client, has a whole treatment plan. He could be civilly committed if the mental health people think he should be, if they think there's some risk of harm.
But
So
is it a civil commitment that starts from scratch or a civil commitment that starts with an NGI? I mean, I think isn't there a difference?
Yes, I think, yes, it would be the civil commitment that goes with the NGRI, yes.
His underlying criminal case was dismissed, correct?
Yes. Yes.
I mean, it had to be because he was never going to be competent.
Yeah, he was, that was,
Yes.
the statute in Section 15 specifically refers to did commit the act, is that correct?
Yes.
It doesn't say determine whether the defendant is guilty of the crime. Are they not different points?
I don't know if they're different points. I don't think they should be different points because you're taking a man's liberty on an indefinite commitment and giving him less than he would have gotten if he had been competent. And he should be allowed to raise all the defenses he could have raised in the criminal case.
Sorry.
No, go ahead.
I'm confused, though, because the statute also, so in addition to Justice Cypher's point, the statute doesn't draw a distinction, the statute doesn't refer to crimes, it refers to acts.
Yes.
It also assumes that the person is incompetent because it's supposed to evaluate the effect of the person's incompetence on the proceeding. So you're saying we're going to prove he's not guilty by reason of insanity, and then we're going to, and then we've got him, but that doesn't seem to be at all what the statute's doing. The statute is focusing on acts and incompetence, and you're trying to put in evidence on something that's inconsistent with the way the whole statute's worded, isn't it?
I'm trying to put in a defense that he could have had in the district court.
But let me just follow up that second. So
Sure.
how is he going to, we know if he's incompetent, doesn't that sort of make the whole inquiry about his mens rea I don't know, maybe the criminal experts can
Wait, no,
explain how
if
that
we
works.
take the Venn diagram, not all incompetent people are NGI, but most NGI people are incompetent. You see what I'm saying?
Right.
So if someone starts out to be not competent, there's
Okay.
going to be an NGI issue.
Right, and they could certainly be not competent at the time of the offense, and then later, through medication,
Yes.
become competent, and
Yes.
then they can be tried for it.
Yes. If he were competent in the district court in the criminal case, he could decide whether or not to raise criminal responsibility. But he's never been restored.
So is one interpretation of the statute, it's this truncated procedure, but in order to go forward, we need to know whether or not this person did this crime or committed the act. Because obviously if the person was wrongful, a misidentification or something like that, we're not going to go forward.
Well, the enumerated rights in Burgess include retention of experts. So I guess my issue is I should be able to retain Dr. Brown to testify on criminal responsibility, as that's a defense. It doesn't limit the kind of defenses he should have. So if he could raise
It's a defense to the criminal charge.
to the act about
Well,
the
that's
commission of
the
the act.
question. Is it a defense to whether one committed an act?
I think he should be allowed to raise that because it's his liberty, an indefinite
I
commitment.
understand, but then I go back to the point of the SDP statute is to protect people from other people who can't control their impulses and their actions,
Yes.
right? So if we are now going to look at that component of, did you know what you were doing when you did it, or did you have the right mental intent, are we not backing up into that point of the statute and basically wiping it out? But because now, the fact that he can't control his impulses or actions goes to his mental capacity, which goes to whether he did the act. I mean, it's somewhat circular to me, and it ends up leaving a hole, I think, in protection.
Well, was two pieces. First, I think it's more fact-specific. In this case, it's, he indecently touches a medication nurse at medication time. There's testimony from Dr. Brown that the medications have generally controlled his behavior, not his delusions.
Whether the charge should have been brought or not is not really the point, though, right?
Right. We're stuck at it happened. We're stuck with what happened. As far as the whole in public safety, if he's committed as NGRI under the mental health statute 123, 16D, the district attorney's office has the right to be heard.
You're asking us to graft that onto this consequence.
I think that, as I analyze it, that would be a next step. The legislature didn't address it, so I guess that would be.
So we'd have to
you.
rewrite the statute to say, by the way, if they're found NGI during this truncated procedure, then they go into the NGI protective field.
Which is already in place, which has already been drafted and in place, so the mechanism is there.
There's a difference, isn't there, between somebody being fully NGI or insane or mentally ill and a lack of criminal responsibility?
There's a, well, NGRI
NGRI
is not guilty by reason of insanity, is what we also call lack of criminal responsibility.
So they're the same thing?
They're the same thing.
Okay.
Yeah, they're not competent to stand trial is the
Well, I
different thing.
know that's different,
Did I
but I'm
misspeak? I'm
just,
sorry.
criminal responsibility and insanity have often been conflated or separated depending on the circumstances. So I just want to make sure I know
For
where
me,
we
they're
are.
the same. The lack of criminal responsibility is a not guilty by reason of insanity. And that's why I say he should,
It's not something that eliminates an element.
that eliminates an element.
Okay.
I don't think it eliminates an element. It's
To
an
a
issue.
crime. Right, okay.
So I think he's entitled to have a defense to be found not guilty on the underlying crime and be out from under the SDP
I see.
petition.
And is that a constitutional argument you're making, or just is this a due process violation you're saying?
Well, it's a good question because the rights are all, I think, mostly conferred by the SDP statute. But I think when you're talking about somebody's liberty, it's a constitutional issue, and they're
Well,
trying to
I
take his
mean-
liberty for indefinitely.
Are you also having a problem with does part of your argument stem from the fact that the two sentences seem not to be entirely consistent? The rules of evidence applicable in criminal, this is in section 15, the rules of evidence applicable in criminal cases shall apply, and all rights available to criminal defendants in criminal trials other than the right not to be tried while incompetent shall apply. After hearing evidence, the court shall make specific findings relative to whether the person did commit the act or acts charged. So you're saying that basically the first sentence gives you the right to do whatever you would have done as you would have done in connection with the criminal case.
And Burgess kind of expands on that with enumerating the rights.
Okay, thank you. Ms. Lazar-Moore, good morning.
Good morning. Ellen Lazar-Moore for the Commonwealth. Judge Tucker correctly excluded from the Section 15 hearing evidence about the respondent's alleged lack of criminal responsibility because the sole purpose of this hearing is to determine if the respondent committed the acts alleged, not whether he can be held criminally responsible for them.
What if the defense had been, I stumbled, and it was an accident when I touched her breast? I didn't intend to do it. I stumbled. Is that excluded because there's no dispute he did the act?
Well, I think that the judge could make that determination in hearing the evidence. If it was an accident, he could find that, although it's not, he doesn't literally have to find that the defendant committed a crime, he could find that that the defendant, in this case, the allegation is that the defendant pushed the victim up against a counter, put his leg between her legs, reached underneath her shirt, and touched her breasts.
I'm not saying that that's going to be his defense here,
Yes.
but let's assume it was somebody was accused of touching a breast or a vaginal area, and the defense was, I stumbled and I fell and I landed on her and I did not intend to do it, but I did it.
Yes. Well, I think I think the judge could hear that evidence and he could make the finding that it was an accident.
And doesn't that mean then it meant that you agree that mens rea, that the intent to commit the act matters?
I think it's different than a determination of what they're calling criminal responsibility. There's no question that the defendant cannot be held criminally responsible. Whatever the finding of this hearing is, he cannot be held criminally responsible. The criminal charge against him has been dismissed. There's no finding of guilt or innocence. This proceeding is civil and remedial. There's no criminal penalty.
But what is, I mean, isn't accident, we have many ways to say somebody is not criminally responsible. You cannot be criminally responsible because it was an accident. You cannot be criminally responsible because you were insane or
Intoxication?
intoxication. I mean, there are other means by which somebody would not be deemed criminally responsible other than insanity. Why are you separating insanity from the others?
Well, I think the way that the statute is phrased, where it says that a judge must make a finding whether the person did commit the act or acts charged.
But he would
That
have done
is-
that, right? Even if he'd done it by accident, he did the act.
Yeah. and-
Yes, and so that's what the judge would make the finding on, and then if the judge found, what in this court in Commonwealth versus Nieves phrased or described, what the judge has to do is making the predicate factual determinations regarding the actions that would ordinarily constitute a crime.
Right, so
So I think a judge could find that, yes, the defendant committed the acts, even if the judge were to find that he's not criminally responsible for them because he could not formulate the state of mind, and yet still permit the case to go forward as it would under sections 13 and 14, and then there would be an evaluation by the experts who would say, okay, he fell on her, he didn't intend to do this, I find he doesn't have a mental abnormality, or he doesn't have a personality disorder, or he's not likely to commit sexual offenses if not confined, because this was an accident.
So in your view, this is just one step in a proceeding that's continuing, and there will be plenty of opportunities for the petitioner to show that he or she is not sexually dangerous.
Yes, this is just a predicate determination that is made before the case can proceed forward through the normal process, which would include...
Right, but if he had become competent, if the same individual had become competent through medication and been tried and been found not guilty, either for reasons of intoxication or reasons of accident or reasons of lack of criminal responsibility, you would not be able to proceed by statute on the SDP because there would not have been the prior sexual conviction.
No, and
So
the
why is
statute
it-
recognizes...
Doesn't the statute try to put the person who's incompetent in the same position as the person who is competent and is tried? Isn't that the legislative intent behind Section 15, is to try to say, I know that he's incompetent, he could therefore not have been tried, but we're going to treat the person as closely as we can to somebody who is competent and does receive the benefit of a trial as to whether or not he or she has committed a sexual offense?
I think that there's an effort to... I don't think that they can ever be put in the exact same position. And I don't think that the legislature intended that the Section 15 trial be exactly the equivalent of a criminal trial, because if they did, they wouldn't have worded it in this limited fashion that the judge, without a jury, will hear evidence and determine only whether the person did commit the act or acts charge,
I
period.
think it's dispositive that they use the word act or acts as opposed to crime.
I do. They don't say crime. They don't say anything about the person's state of mind. They limit it to an examination of the act.
That's
And I
true,
think
but-
that that's significant.
That's true, but the prior sentence does say that the rights, all rights available to criminal defendants at criminal trials other than the right not to be tried while incompetent shall apply.
Yes, and to me, that includes that when someone is presenting an expert, that that expert's testimony be relevant to the issue before the fact finder. And in the Commonwealth's view, this evidence is not relevant because the defendant cannot be held criminally responsible after this hearing. That ship has sailed. The criminal charge is gone. It's been dismissed. It's not before this court. When the defendant or the respondent continually says, I have a right to put forth evidence to be found not guilty, but there is no finding of guilt or innocence. If the judge here holds the hearing and finds that the defendant did commit the act alleged, this doesn't go on the defendant's Board of Probation report as conviction of a crime.
Do you think it's a
There's no
problem
criminal.
if the defendant goes on and is found to be SDP? Do you think it's a problem at all that he was never convicted of the underlying offense?
No, because that's the way the statutory scheme is set up. This court has approved that in Commonwealth versus Burgess and Nieves. Burgess deals with someone who's incompetent to stand trial on the sexual offense, and this court approved that process. And then Nieves deals with someone who was convicted of the sexual offense but is incompetent now in the SDP, and this court also approved that process.
You think it's, that we shouldn't graft onto this section if he were to be found NGI after this Section 15 procedure, the traditional NGI protections? That would just be rewriting the statute.
I just think it's not there. I mean, in one sense, I'm hesitant to say, no, we couldn't then commit him under 123, because if I lose, he walks out the door. But on the other hand, I've read and reread Chapter 123, and I just don't see anywhere in there where someone in the position of this respondent If the judge puts in evidence or allows in evidence that he's not criminally responsible and then finds him to be not criminally responsible, can now suddenly be treated as though there's a criminal case pending or he was found not guilty after a full criminal trial. I just don't see anywhere in the statutory language where that fits. I also think, frankly, that it's really not ripe, and it's asking this court for an advisory opinion when the respondent argues, here are the things that should happen if this were to happen. I mean, right now, there hasn't been a Section 15 hearing, there hasn't been evidence of criminal responsibility, the judge hasn't made a determination of no criminal responsibility, he hasn't then gone on to say, okay, now I will or will not commit him. I feel like that's something that the trial judge in the first instance should be given the opportunity to do with input from the parties before that's raised to an appellate court to review. But I do think that the fact that the legislature chose this very limited language about did commit the act or acts charged means that this was not meant to be a protracted proceeding about experts on both sides, about criminal responsibility. And again, yes, Burgess does include in the list of rights that a respondent in an SDP case has the ability to present expert testimony. But that's always limited by the principle that evidence has to be relevant. I mean, I could envision a case where under a Section 15 hearing, a case that's much more complex, let's say there's DNA evidence about the identity of the perpetrator, or there's cause of death if there was a sexual offense and then a death. There could be a much more...
What if the defense is consent? Yes, I had sex with her, but he or she consented. Did the act charged? The act charged is indecent assault or rape.
Well, then it wouldn't be an assault if it was a consensual touching.
So the act is the crime.
Well, I mean, it says the act or acts charged. So I would say still there is some use of the definition of what the crime is in terms of its elements, but I think it's sort of assumed that when we're dealing with someone who's incompetent to begin with, that this is a proceeding that only applies to people who are currently incompetent, that the issue of the person's mental state is not going to be litigated in the sense that it would be in a regular criminal trial, which is why the legislature chooses the words the act charged instead of committed the offense or committed the crime or had the mental state required for the crime.
But they could have become incompetent after the event's charged. They could have been in a car accident and had brain injury. They don't necessarily need to have been incompetent at the time of the offense.
Well, it's the Commonwealth's position that, let's say the judge were to allow in evidence of lack of criminal responsibility and even make a finding that the respondent is not criminally responsible for the indecent assault and battery, that the judge could still find that the respondent committed the act charged and move ahead with the SDP proceeding. So I think that that shows that this testimony isn't really relevant to the determination that the judge is supposed to be making here, which, as I said, in Nieves, this court called making the predicate factual determinations regarding actions that would ordinarily constitute a crime. So there's an acknowledgement that it's not a crime now. It's not a finding that the defendant is guilty. It's not convicting him of a crime. It's just that we're not going to move forward on an SDP proceeding if it turns out he's not the one who did it.
But doesn't that give the SDP proceeding more information? So if a judge makes a finding that there was either consent, intoxication, lack of accident, or criminal responsibility, then that can be, but the person did the act, that can be taken into account down the road.
Yes, and there's language in the Burgess case that acknowledges that, where it talks about in Section 15, where it says that the court has to make specific findings relative to whether the person did commit the act or acts charged, the the extent to which incompetence affected the outcome of the hearing, its effect on the person's ability to consult with counsel, et cetera, et cetera. And I believe it's in Burgess where it says that the purpose of these extensive findings, in addition to allowing for appellate review, is to inform any later review under sections 13 and 14. So now the qualified examiners who are doing the 60-day evaluation have that information when they're determining if there's a mental abnormality or personality disorder or likelihood of reoffense. And then if it gets through that to trial, the fact finder also has that information.
But doesn't that undercut your argument that if this is information that can be taken into account down the road, why not? Why not have it litigated here?
Because frankly, I just think that it's not relevant to the determination that the judge is supposed to be making now. If it's just...
How would the other things be relevant that you said it would be okay to do? Like you could put in evidence as to accident, that would be relevant. Why would that be relevant when this is not?
I think that there was a very, very limited sort of, I guess, offer of proof about what Dr. Brown would say. There were just 2 places in his report where he even mentioned all criminal responsibility. One wasn't even an opinion. He just said he believed that it would be quite likely that at any criminal trial he might be found not criminally responsible. And then in another place he said that his schizoaffective disorder could render him not criminally responsible in the criminal case. So I think that based upon the limited amount of information that we have, all he is essentially saying is that he cannot be criminally punished for these acts, which is something that we already know. I don't believe that's relevant to the decision that's being made by the judge in the Section 15 hearing because, as I said, whatever is found after this hearing, he's not going to be criminally punished for these acts.
So you say the information goes to the qualified examiners, is that right?
Yes.
So is it relevant to the inquiry they're doing? If they find out you've got all this information that he's potentially insane?
They have the reports that are done they have everything that was before the judge at the probable cause hearing, which includes the reports of the Commonwealth's expert and the respondent's expert. They have the reports on the incompetency,
Right,
which
but this is a
include
different-
all of his...
But now you would have a judge making these findings as opposed to a QE reading these in a report, right?
I'm sorry, I didn't...
That you would have a judge making these findings with an expert subject to cross-examination.
About lack of criminal responsibility. Right. But I don't believe that a judge actually would even make that finding because, again, it's did he commit the act charged. So to put this evidence before the judge when I don't believe it's relevant to his making the finding about whether he committed the act charged, I think is beyond the scope of what this hearing was meant to be. And again, really, in looking at the SDP statute as a whole, where this is just one piece before it would then move on to evaluation by the qualified examiners and possibly trial, would expand this hearing far beyond what was intended by the legislature.
And do you think that the reason that this is in this section, that this section applies only to people who have been found to be incompetent is because both that, it contemplates the mental element in that we know they're incompetent, so we have to determine whether they've committed the act. But to go any further than that, we're going to circle back into incompetence and then into all the other things that are considered in the SDP statute. It seems, I don't know if I'm making sense, but
I think it might be. I mean, it's of course limited because the other 2 categories of people who are subject to possible commitment, they already have a sex offense conviction. So it's not necessary with those other 2 categories. Even someone who's presently incompetent in the SDP case, if they were presently incompetent but were competent at the time of a conviction, you don't have to go through this. So you at least need this sort of predicate finding of some sort of sexual acting out in order to move to the next phase. But I do think that one of the reasons that it is limited and meant to be limited is because of where it goes after this, and as you were talking about, sort of the volitional component of what has to be shown down the road anyway about the likelihood of sex offense and the mental abnormality and personality disorder.
Okay, thank you.
Thank you.
And we'll take our morning break.